so proud to officially welcome you to the Blake Brown TYB community. Community is so important to us at Blake Brown. We respect each other. We work hard to create great things, products that work for us, but products that we want you to love, smells that we want you to love, packaging that we want you to love, products that you feel good about, that are clean.
This lemon is too big to fit the right way, so we're gonna do it upside down because you just improvise. I feel like this is gonna end up on OnlyFans, like me leaning over, chest falling out, squeezing this lemon. This is not suitable for work. But for It Ends With Us, I really like the way my husband dresses, and I also really love the way Gigi Hadid dresses.
After months of explosive allegations, celebrity drama, and media spectacle, the actress finds herself backed into a legal corner with seemingly no way out. Her legal team has made moves that many experts are calling reckless, even desperate. Court filings from Friday reveal something shocking. Lively appears to have abandoned key claims in her case against Justin Baldoni and Wayfarer Studios. The defense has systematically dismantled her arguments, one by one, exposing fatal flaws that could end this case before it ever reaches a jury. Could this high-profile lawsuit collapse entirely? Before we dive in, make sure you're subscribed and hit that notification bell. This story is developing fast, and you won't want to miss what happens next. Drop a comment and let us know. Do you think Blake Lively's case can survive? Let's break down exactly what happened in court. On Friday, Blake Lively's legal situation took a devastating turn. Here's what makes this particularly damaging. Lively's legal team chose an unusual and risky strategy. Why does that matter? Because by failing to respond to specific arguments, they may have inadvertently conceded defeat on several fronts. The defense, led by powerhouse attorney Alexandra Shapiro, representing Wayfarer Studios, wasted no time capitalizing on these mistakes. Let's start with the core problem. Blake Lively made two catastrophic errors when she originally filed this lawsuit. First, she never properly filed her complaint on behalf of It Ends With Us, LLC, the production company entity. She later amended the complaint, but by then, the statute of limitations window had closed. She never received a proper right to sue notice for that entity. In employment law, that's a foundational requirement. But there's an even bigger issue at play here, one that could sink her entire case regardless of the merits. If that logic makes sense to you so far, hit like and subscribe because this case only gets more complicated from here. California's Fair Employment and Housing Act, known as FEHA, is the law Blake Lively is relying on for many of her harassment and retaliation claims. The problem? FEHA has strict territorial limits. Wayfarer's attorneys argue that Lively has utterly failed to establish that nexus. The film was shot primarily in New Jersey. The alleged incidents took place in New Jersey. The companies involved were operating under New Jersey law. But wait, there's more. Remember how this case began with complaints filed to the Equal Employment Opportunity Commission, the EEOC? If you think it's the second, go ahead and like the video and subscribe. You'll want to see how this unfolds. For the first time, Lively has revealed that the EEOC dismissed her case on January 21st, 2025. That dismissal came remarkably fast, within just 4 weeks. The EEOC typically takes months, sometimes years, to investigate claims. A dismissal this quick usually indicates serious problems with the complaint itself. Legal experts believe the EEOC likely found that Lively's claims were time-barred. Federal law requires employees to file harassment complaints within 300 days of the alleged incidents. But Lively's complaints reference events from May 2023, and she didn't file with the EEOC until December 2024, well beyond that 300-day window. If your answer is no, you already know where you stand. When the EEOC dismisses a case that quickly, it's essentially saying this complaint lacks legal standing. That's not a good look when you're trying to convince a federal judge that your harassment claims are legitimate. Now, let's talk about what Lively abandoned. In employment law, that's crucial. Wayfarer pointed out that Lively never actually identified what adverse action occurred. Her compensation stayed the same. Her role expanded, if anything. She received the producer credit she wanted. She got endorsements for industry awards. By not responding to these arguments, Lively's team has essentially conceded the point. That's not hyperbole. What do you think? Was this a strategic miscalculation, or were Lively's attorneys simply unable to answer these challenges? Drop your thoughts in the comments. Let's rewind for a moment and talk about how we got here. This legal battle stems from the production of It Ends With Us, a film adaptation of Colleen Hoover's best-selling novel. Blake Lively starred in and eventually took significant creative control over the project. Justin Baldoni directed and co-starred in the film. Behind the scenes, tensions reportedly escalated. Lively has alleged that she experienced harassment and a hostile work environment during filming in 2023. Her lawsuit claims that Baldoni and others engaged in inappropriate behavior, made unwanted comments, and later retaliated against her through a coordinated public relations campaign. The lawsuit, filed in late 2024, painted a picture of systematic abuse and corporate retaliation. But as discovery proceeded and legal filings emerged, the narrative began to shift. Key figures in this case include Justin Baldoni, the director and actor, Jamie Heath, a producer on the film, and Wayfarer Studios, the production company behind the project. Lively claimed these parties worked together to damage her reputation after she complained about on-set conduct. The case involves multiple legal claims: sexual harassment, hostile work environment, retaliation, defamation, and civil conspiracy. Understanding the employment relationship is critical here. Was Blake Lively an employee of the production, or was she an independent contractor? The defense has presented two entirely separate pathways for the judge to dismiss this case, and both are grounded in solid legal principles. Path 1. The judgment on the pleadings. This focuses purely on what's written in the complaint itself. No outside evidence, no discovery materials, just the legal sufficiency of the claims as filed. Wayfarer argues that even taking everything Lively alleged as true, her complaint still fails as a matter of law. Why? Because FEHA cannot be applied extraterritorially. California employment laws protect California workers for conduct that occurs in California. Courts have repeatedly held that you cannot use California law to regulate employment relationships that exist entirely outside the state. Lively tried to argue that contractual choice of law provisions override this limitation. But the defense counters with the simple truth: contracts cannot expand the statutory jurisdiction of state laws. California has clearly stated that FEHA does not apply to out-of-state conduct involving out-of-state residents. A contract provision cannot change that fundamental limitation. If the judge agrees, every FEHA claim disappears. And since many of Lively's harassment and retaliation claims rely on FEHA, losing this argument could be catastrophic. Path 2. The summary judgment. Motion. This path requires looking at the evidence that's been gathered during discovery. Here, the central question becomes: was Blake Lively an employee or an independent contractor? This matters enormously because federal anti-discrimination laws, Title VII, for example, only protect employees. Independent contractors generally cannot sue for employment discrimination. Wayfarer argues that Lively was unquestionably an independent contractor. Here's their evidence. She worked through her loan-out company, Blake Hill Inc. The production paid her company, not her directly. She negotiated her own rates, she controlled her schedule, and even had the production alter filming dates so she could work on another project. She exercised tremendous creative control over the film, eventually receiving a producer credit. California has specific tests to determine employment status, and Wayfarer methodically walks through each factor. The business-to-business exception applies when two companies contract for services. Blake Hill Inc. contracted with the production company. The work was performed pursuant to that business relationship. That's a powerful statement. And if the judge agrees that she was a contractor, not an employee, then her Title VII claims, and potentially all her employment-based claims, fail entirely. Now, let's talk about what's really happening here beneath the legal jargon. Alexandra Shapiro's opening statement in the summary judgment response was absolutely scathing. What follows is a methodical destruction of Lively's narrative. Directors yell, tempers flare, creative differences lead to arguments. Actors and directors clash over artistic vision. These are not hostile work environment violations. They're the reality of collaborative filmmaking under pressure. The defense points out something remarkable. Lively has struggled to identify what specifically constitutes sexual harassment in this case. In her own filings, she narrowed her claims down to just 2 incidents involving producer Jamie Heath. The first incident, Heath allegedly showed her a video related to his child's birth. This happened while the production was preparing to film childbirth scenes for the movie. Heath showed the same video to Baldoni and another crew member, who found it completely inoffensive. Was this inappropriate? Or was it a producer sharing relevant reference material for a scene they were about to shoot? The second incident, Heath walked into Lively's trailer after knocking. In other words, she acknowledged at the time that she didn't believe his actions were intentional or malicious. These are the 2 incidents that supposedly justify months of litigation and millions of dollars in legal fees. That's a critical point. Defamation requires false statements. Lively claims her reputation was destroyed, but the defense argues that everything published about her was either true or constituted fair comment. Old interviews resurfaced. Her own past statements were shared. The defense also reveals something telling about Lively's motivations. She undertook significant editing work on the film without initially receiving a producer credit. That credit wasn't granted until June 2024, after production had wrapped. Why did she do all that work? To qualify for a Producers Guild of America mark, a prestigious industry credential that would place her among an elite group of actress producers. In other words, she wanted the accolades. She wanted to be recognized as a serious creative force, not just an actress. The defense uses this against her, arguing that her role expanded during production, not contracted. She got more responsibility, more recognition, more opportunity. Where's the adverse employment action? Where's the retaliation? What makes this particularly damaging is what Lively didn't defend. She abandoned her contract claims against Wayfarer. She failed to respond to arguments about damages. Legally, that's a non-starter. You can't seek damages on behalf of companies that haven't sued. Let that sink in. This case began with explosive allegations of on-set harassment. Media coverage painted a picture of serious misconduct. And now, in her own legal filings, Lively has walked back most of those claims. What remains? A comment about circumcision, a topic she initiated, discussions about intimacy while choreographing sex scenes for the film, a remark about her weight made to someone not even involved in the production. The defense dismantles each of these methodically. Talking about sex while planning sex scenes isn't harassment, it's necessary creative collaboration. An offhand comment about weight, while perhaps insensitive, doesn't create a hostile work environment, especially when made to a third party. This raises uncomfortable questions. Did Blake Lively file this lawsuit knowing her harassment claims were weak? Was this primarily about reputation management after a film production went sideways? The defense certainly seems to think so. Think about that. By Lively's own admission, any issues that arose during the first phase of filming were addressed. The second phase of production proceeded smoothly. Everyone worked together. The film was completed and released. And yet, months later, after tensions over creative control and public reception of the film, Lively filed a massive federal lawsuit. The timing matters. The film underperformed expectations. Lively faced public criticism for her promotional interviews. Old footage of her making dismissive comments resurfaced online. Did she file this lawsuit to control the narrative, to shift blame for the film's reception, to explain away negative publicity? The defense suggests that's exactly what happened. They point out that while Lively accuses them of hiring PR firms to attack her, she and her husband openly criticized Baldoni and generated negative press against him. In fact, Wayfarer argues they hired crisis management professionals not to attack Lively, but to prepare a defense in case she went public with allegations. Her legal team faces an almost impossible situation. They have to defend against 2 separate motions, each offering the judge an easy off-ramp to dismiss the case without even addressing whether harassment occurred. The judge could rule that FEHA doesn't apply because the conduct happened in New Jersey. Or the judge could rule that Lively was an independent contractor, not an employee. Or the judge could rule that she failed to establish an adverse employment action. Case dismissed. The defense has given the court multiple options. And that's strategic brilliance. The judge doesn't have to make a controversial ruling about whether Blake Lively is lying about harassment. He can simply dismiss the case on procedural or jurisdictional grounds. That's what makes Lively's decision to abandon so many arguments so puzzling. By not defending against the judgment on the pleadings, her team may have handed the defense an easy victory. Legal experts watching this case are stunned by the risks Lively's team has taken. One thing is clear: Blake Lively's lawsuit is in serious trouble. What began as a media spectacle may end with a quiet dismissal based on legal technicalities. And if that happens, the broader implications are significant. This case will serve as a cautionary tale about using litigation to manage celebrity reputation. Most importantly, it may demonstrate that even in our current cultural moment, courts still require evidence, legal standing, and proper procedure. Allegations alone are not enough. What do you think? Will Blake Lively's case survive these motions? Or is this lawsuit dead on arrival? Do you believe her harassment claims are legitimate? Or is this reputation management gone wrong? Drop your thoughts in the comments below. If you found this analysis valuable, smash that like button, subscribe, and hit the notification bell so you don't miss our coverage as this case develops. We'll be here breaking down every filing, every motion, every twist in this ongoing legal battle. Thanks for watching. We'll see you in the next one.